Some frequently asked questions about ballot measure titles. What are ballot titles used for? According to California's elections code, ballot titles are used for measures that are submitted to the voters of this state. Are there rules related to ballot titles in California law? Yes, and these rules are found in the California Elections Code, Division 9, Chapter 1, Article 5. What happens when it's determined that a measure will appear on the statewide ballot? Elections Code Section 9050 requires that after the Secretary of State determines that a measure will appear on the ballot at the next statewide election, then the Secretary of State is required to promptly transmit a copy of that measure to the Attorney General. What does the Attorney General do with the measure? The Attorney General is required to provide and return to the Secretary of State a ballot title and summary and a ballot label for each measure that's submitted to the voters of the state. And they have to do that by a date that's sufficient to meet the State Voter Information Guide public display guidelines issued by the Secretary of State. What's required of each measure? Elections Code Section 9053 requires each measure to be designated on the ballot by the ballot label that's certified to the Secretary of State by the Attorney General. And finally, are any translations required? Yes, Elections Code Section 9054 specifies that whenever a city, county, or a city and a county is required by the Federal Voting Rights Act of 1965 to provide a translation of ballot materials in a language other than English, then the Secretary of State must provide a translation of the ballot title and summary and the ballot label prepared in that language for the voters for each state measure in a statewide election, and that has to be done not later than 68 days before that particular election occurs.